Hello, this is David Olshan of Nevada Legal Services. This is another in our series of substantive law videos regarding bankruptcy. I am going to go over the meeting of the creditors, which is required in a Chapter 7 or 13 bankruptcy. We want to take some of the fear and uncertainty regarding these proceedings out of the equation and let you know what's expected at the meeting of the creditors. The meeting of the creditors is required in 11 United States Code 341. It's sometimes referred to as a 341 meeting. It is scheduled about 30 days from the date you file your bankruptcy. During this COVID crisis, they are over the phone, but usually they are in a meeting room in the bankruptcy court. When you file your bankruptcy, a 309, a notice goes out, and it does notify all your creditors of the meeting of the creditors. You must bring documents, submit documents to the trustee prior to the meeting of the creditors. It's usually about 1 week before the meeting of the creditors. You usually need 6 months of bank statements, and you count back from the date of filing. 2 years of tax returns. If you haven't filed for taxes, it's not a problem in a Chapter 7. You can do a declaration. If you operate a business, you would have to include your profit and loss statements in your tax returns. You need a copy of your driver's license and social security card, and there is something called a trustee's questionnaire that's also needed. It's a 4-page document, and you need to complete that and turn it over to the trustee prior to the meeting of the creditors. Although it's called a meeting of the creditors, creditors usually do not attend. The trustee will be there. A trustee is a private bankruptcy attorney employed by the bankruptcy court. And the trustee's job is to swear you in and make sure that your forms are in order, that you are the real person who filed, and that you have not committed bankruptcy fraud. The trustee will call your name, you step up, produce your driver's license and social security card. If you have other forms with your social security number on them, like a tax form, that should be sufficient. The trustee will then swear you in. You swear to tell the truth, and not telling the truth may result in a denial of discharge or bankruptcy fraud. So always, always, always tell the truth. The trustee will then ask you some specific questions that are mandated by the U.S. Trustee's Office. Some common questions: did you read and sign the petition and schedules that you filed? Did you include all your income and assets? Have you read the bankruptcy information sheet? In Las Vegas, the bankruptcy information sheet is outside of the meeting room, so just take it and read it. The trustee will ask you about that. It's also in your original petition, so you probably read it anyway. Is the information in your schedules true and correct? Why have you filed for bankruptcy protection? So those are the questions. Those are the things that the trustee is interested in. Have you disclosed your income and assets? Are you trying to hide anything? Have you paid off certain people? Is there money that the trustee can recoup? Those are some of the issues. The trustee is there. The trustee is not really your friend. They're there on the behalf of the bankruptcy court, but these are friendly, congenial proceedings that you really don't need to worry about unless you have something to hide. If you have missed anything in your schedules, like bank statements, tax forms, the trustee will give you extra time to supply that information. So don't think it's all or nothing. You try your best. You file in good faith. If you're missing something, the trustee will allow you time to supplement the record and get everything right. If you miss the meeting, let the trustee know. Usually, you must miss 2 of these meetings of the creditors before the trustee will try to dismiss your case. But if you let the trustee know and you have a valid reason, and now during the COVID crisis, there's fewer valid reasons, but if you do have a valid reason, let the trustee know that the trustee will happily continue the hearing. After the meeting of the creditors, the trustee will dismiss you. The trustee will then issue a report of the meeting of the creditors, and 60 days later, if you have paid your filing fees, a discharge will be entered. And if you are reaffirming a debt, trying to redeem property or surrendering property, don't forget to follow up by sending your Schedule 108 to that creditor and following up on the reaffirmation or whatever you're doing. If you don't know what I'm talking about here, don't worry, your lawyer should know, but that's something to know. Like if you are behind in your car payment, you will have to reaffirm the note that secures the car, and you do that through the bankruptcy by filing a reaffirmation agreement. If you need help with a bankruptcy, if you cannot pay your bills or want to save your home or car, please contact us. In Las Vegas or Southern Nevada, our number is 866-432-0404. In Reno or Northern Nevada, our number is 800-323-8666. We provide free legal assistance, so we may be able to help, and we will be posting more informational videos about bankruptcy in the near future.